Assalamualaikum warahmatullahi wabarakatuh. So, this day I want to presentation about civil law in Finlandia. So, first of all, let me introduce myself. My name is Firnanda putri azizah, and you can call me Nanda, and my last name is 645. So, let's get into the material. Finland in civil law. Finland has a parliamentary democracy with a multi-party political system. The head of the government is the prime minister who head the executive branch of the government and the head of the state. The president of Finland is in charge of the court foreign policy. The executive, legislative, and judicial powers are set out in the constitution of Finland. The Constitution is the basis of the legislation and iterates the executive power and function of the government. It laid down the fundamental rules, values, and principles of Finnish democracy. So the first one is legal system. Finland has a civil law tradition. The Constitution of Finland laid down the right, procedure, and process to be followed in enchanting and implementing legislation. The judicial is independent from the legislature and executive branch, and judicial process are governed by, by law and court under the Constitution. Courts are supervised by the Chancellor of Justice and the Parliamentary Ombudsman. In matter of law, the courts are independent. The Ministry of Justice does not supervise court decision, nor does it in any manner influence the function of the judicial. The court structure in Finland can be divided into the first one is district court, the second one is administrative court, and the third one is special court. And the second one is legal structure. In Finland, the name for a lawyer is lakimies. The legal profession in Finland can be divided into the first one is lawyer who are member of the Finnish Bar Association or FBA use the title asiana jaja or advocate, with, which mean attorney at law. To become a member of the bar, a lawyer must be over 25 years old, have a master's degree in law, and minimum of 4 year legal experience, of which 2 years must be in a law police. Additionally, the lawyer must have passed the bar exam. And the second one, public legal aid attorney at attorneys are a lawyer employed by Public Legal Aid Office or PLAO. They are appointed by the Minister of Justice and have to meet requirements for their appointment, such as a master degree in law, experience of advocacy, or adjudication, and many are also members of the Bar Association. They are supervised by the Bar Association in practice of their membership and are extended to follow professional ethics laid down by the Finnish Bar Association. And the last one, a licensed legal counsel must have a master degree in law and should have relevant experience or pass the bar exam and must be authorized by the Finnish Bar Association Board. The license can be revoked in certain situations by the Bar Association. And the next one is Process and proceedings overview. The first criminal procedure. The criminal procedure has four stages: pre-trial investigation, considering of change, court hearing, and enforcement of penalties. A criminal investigation starts with a police report that may be made by the concerned party, or if the police suspect a crime has been committed, the police or authorities responsible for criminal investigation will conduct a criminal investigation. The criminal investigation is led by the police and the prosecutor. Upon completion of the criminal investigation, the criminal investigation report and supporting documents are submitted to the prosecutor. This is called the pre-trial investigation. After the pre-trial investigation is complete, and a prosecutor receives a record of the pretrial investigation from the police, the prosecutor decides the further course of action that could result in either taking the matter to court, bringing charge, or making the decision to waive charge issue. In the case of petty crimes, charge may not be pressed. Nonetheless, in case where the victim wants to bring charge, she or he can do so. This stage is called the considering of charge. Once the charges are brought to court, the defendant is notified of the charge brought against him. A summons is delivered and the defendant is provided with an opportunity to it. In most cases, the summons also instruct the defendant to appear in court in person, but it may also request that the defendant respond to the charge is writing before the trial commences. After that, closing argument of both parties will be heard and the court will make a ruling at the hearing. If the defendant, the prosecutor of the plaintiff, is dissatisfied with the district court decision, he or she can appeal to the Court of Appeal. And the second one is a civil procedure. The Code of Judicial Procedure is the main statute that governs civil proceeding. The civil procedure can be divided into the distinct stage, that preparatory stage, and the main hearing in the preparatory stage. Parties submit a number of documents along with filling of the case subsequent. The preparatory stage arguments are heard, written evidence is present in court, and witnesses are cross-examined. The hearing can take from one several days. There can be application for summary procedure if the matter is uncontested, but if the defendant contests, the same procedure are held as per the above procedure. The third one is alternative dispute resolution. An out-of-court settlement is not compulsory in Finland, but it is possible in the majority of cases, such as business disputes between employers and employee, dispute between customer and businesses, and dispute relating to landlord and tenants. Mediation is provided in civil and criminal matter in Finland. For sake of clarity, mediation in In criminal cases, will be referred to a victim offered mediation or VOM. Under Chapter 5, Section 26 of the Code of Procedure, it is stated that in civil case, court must establish whether the matter can be resolved amicably. In civil cases, mediation can be initiated when at least one of the parties involved is a natural person and dispute amount is minor. Mediation should not be applied in case of sexual offense or case of intimate partner violence with a prior history of violence or mediation. The police have also been instructed to prioritize complainant interest and apply careful considerate when assessing the sui- suitability of more sensitive case for mediation. In practice, mediation is more commonly suggested to younger age group and less directed to criminal case where the parties involved have a permanent criminal history. Currently, the most topical issue regarding victim offer mediation or VOM regard the application of mediation to case of intimate partner violence. The current decision regard whether the regulation for this need to be further developed. And the last one is simplification of law and bypassing legal process. In civil cases that are undisputed, specifically case concerning unpaid rent, consumer credit, and phone and electricity bills. A district court can apply a summer procedure, mediation, and process relating to mediation, especially in civil case, follow a simplified procedure and significantly reduce legal costs. They includes criminal case where mediation is permitted, thus influencing the verdict and the nature of penalty imposed by the court. So that's it about civil law in Finland. That's it for me. Thank you, ma'am.